Hey there, Tony DeWitt here. I'm a retired Missouri attorney now living my best life on a beach in Florida. I offer content and commentary on current events in the law as well as some general legal topics, but I do not dispense legal advice by video. With that understanding out of the way, here's what we're discussing today. The Trump presidency is going to give us a lot of things to talk about in a legal context. Now, I'm going to try to do that without political spin and just talk about the law. There's going to be things I like about some of what Trump does, and there's going to be things that I don't like. But I'm going to try to keep my biases out of the content to the extent that I can. And if you feel that something was particularly slanted one way or another, let me know, and I will certainly try and remedy that. Today we're going to talk about birthright citizenship, and I'm going to give you the straight scoop on President Trump's executive order, what it means, and whether it's going to survive review. I have to say, this may not be a popular video, and many may not like the answer to the question, but I feel like it's more important to be honest than be popular. So a little bit of background sometimes helps, and so that's where I'll start. When President Obama decided to bypass Congress and effectively legislate with what he called a pen and a phone, the media and Congress both had kind of a attitude about it. The idea that executive orders, which were designed to be written instructions on how the nation is supposed to execute the laws, they were not designed to change the laws. When that became the appropriate way to fix problems that Congress wouldn't take on, that's when we started having problems, and that's when litigation started to be a key part of how either party went about fixing what they saw the overreaches of the other party were. When President Trump took over, he effectively undid a lot of Mr. Obama's actions while he took a few of his own without congressional approval. And then enter President Biden, and he does much the same thing with a bunch of executive orders. And now we have President Trump again, and he's right back at it with over 100, I think it was like 190 executive orders on the first day. The whole idea of executive orders is that it's supposed to be direction to the individual agencies, the Secretary of the Army, the Secretary of the Navy, the Secretary of Homeland Security, the Secretary of State, the FBI, Department of Justice, all of those about how to execute a particular law, how to exercise their discretion when they have discretion, because DOJ, for example, has prosecutorial discretion, and they can decide what they want to take on and what they don't. And obviously, an executive order can help guide that discretion. The reason this is a problem, the reason executive orders are a problem, is that the founders of our nation set up three equal branches of government so that we'd have a republic that would work in one specific way. Congress passes the laws. Now, the executive can certainly recommend them, and they do all the time, and they have since Washington's time. And the executive then executes the laws passed by Congress. And if there is a dispute, then that's when the third branch of government, the court system, that's when they get involved. The founders did not make the chief executive, the president, a king who could rule by fiat. They had already seen that movie, and I don't think they liked the ending very much. As a lawyer and an officer of the court, I know that I can be sanctioned if I make an argument that's not supported by law or based on a good faith attempt to change or modify a law. And normally when we're thinking about changing or modifying a law, we're talking about common law, prior precedent, court rulings that maybe we don't agree with. But politicians are not held to that same standard. Now, the argument made by President Trump is that the 14th Amendment never provided for citizenship for people who came here illegally and had a baby. Well, he's right in that assertion to an extent. The 14th Amendment was designed to give citizenship to former slaves who were brought here against their will. They didn't cross the Rio Grande to get here. They weren't looking for a job. They were chained and drug here like cargo. They had no rights. They could be beaten, they could be bought, they could be sold, sometimes they could even be murdered without any consequence other than the loss of revenue that they could produce. They were the furthest thing from illegal immigrants. Their immigration was compelled by others. So the evil the 14th Amendment sought to fix was denying citizenship and its protections to millions of slaves. By 1868, when the amendment was ratified, almost all of the slaves freed by the 13th Amendment had been born in the United States, slavery having existed since well before the Revolutionary War. Thus, the language of the amendment began with that qualifier. At the time, no one thought about anchor babies or illegal immigration. Now, the emotional part of this argument is that America should be for Americans, and the happy accident of somebody giving birth on U.S. soil should not result in them being an American simply because they were physically present when their physical presence in utero was unlawful. The contrary argument from those who would love to see this executive order declared unconstitutional is that the 14th Amendment means what it says. All you need to do is read the language, they say, and you know that this executive order is wrong. And the emotional part of their argument is similarly compelling. Many of these people were tortured in their own country, and they left for a better future in the United States. They're willing to work hard, and the system for applying for an immigrant visa is difficult and in some respects unreasonable. The video of the women crying at the southern border when Trump took office has been played on a loop on X. And essentially, what he did was he cut off their ability to come in through the Customs and Border Protection app. So both sides have strong emotional arguments, but it's the legal argument that counts. So let's start with how this gets into the court. Now, Trump is an acknowledged conservative, and many on the Democratic side of the aisle are far more liberal. The District of Columbia is the most liberal court in the country, and the D.C. Circuit Court of Appeals is notoriously liberal as well. And I would point out that D.C. is the only place where they have a district court and a court of appeals that does nothing but handle the appeals from the district court. If someone was looking to challenge this executive order, the best place to go would be to the D.C. Circuit. And the D.C. Circuit Court is no fan of Donald Trump. They were willing to, at some level, ignore binding precedent from the Supreme Court as to presidential immunity to re-indict him and recharge him with January 6 criminal conspiracies for acts he undertook as president. And that's what happens when a judge is too close to the issues that they're deciding. There is a theory that the people inside the Beltway live sort of in a bubble, and that their experience, particularly their life experience, does not really square up well with what the rest of the country experiences during a presidency. If someone was looking to challenge this executive order, the best place to go would be to the D.C. Circuit. And the D.C. Circuit Court is no fan of Donald Trump. They were willing to, at some level, ignore binding precedent from the Supreme Court as to presidential immunity to re-indict him and recharge him with January 6 criminal conspiracies for acts he undertook as president. And that's what happens when a judge is too close to the issues that they're deciding. There is a theory that the people inside the Beltway live sort of in a bubble, and that their experience, particularly their life experience, does not really square up well with what the rest of the country experiences during a presidency. And so that may be part of why they would want to go to this court, because it is in that bubble. Now, the bottom line is, if that court has an opportunity to poke its finger in Donald Trump's eye, they're probably going to be happy to do it. You might wonder if conservatives could tee this up and get a ruling from a more favorable court, and the answer is no, but I'll explain that in a moment. But the people who seek to challenge this will either go to the District of Columbia or to San Francisco to challenge this, because that gives them either the D.C. Circuit, which is liberal, or the Ninth Circuit, which is also very liberal. District courts, though, have a lot of cases, and they get a lot of these kinds of requests for rulings, and the judges traditionally do not write long opinions given their rationale for ruling. But certainly, if the executive order is challenged in either of these two places, it will be declared unconstitutional, setting it up to go to the Supreme Court. Now, that challenge won't happen right away. In fact, it can't happen right away. Currently, no one is affected by that EO. It doesn't go into effect until 30 days from January 20th, and it also applies only prospectively. So, children who have already been born here are not affected by that executive order. In order to have a case or controversy capable of being resolved by the courts, you need to have standing. And standing requires someone who has a real, concrete, and particularized interest in challenging that executive order. Well, clearly, a child born after the date it goes into effect to parents who were here illegally would be just that kind of child who would be denied citizenship under this EO, and he would have standing to challenge it. By the time they find that person, though, the pleadings will already have been drafted, and there'll be placeholders there that someone with search and replace can fill in with a name, because they're working on all of this right now. It has to wait until they can be identified before it can be filed, because no one has standing, but they're already working on it. And of course, the reason that conservatives can't go to a friendly court and ask for a declaratory judgment is because their interest is neither concrete nor particularized. It's a generalized interest in this particular EO. So there's no way for them to assert standing that would stand up at the Supreme Court, because the Supreme Court is very hung up on the idea of standing, as they should be. But like I said, right now there are lawyers on both sides of this who are looking at this issue. They're dredging up everything the court has ever written on the 14th Amendment. And they're going to the congressional debates from when it was instituted, and they're looking at the state legislature debates for when this was ratified. And what they're looking for is contemporaneous rationales that were employed in support of the amendment, as well as those that were articulated against it. Expect that the lawyers doing this case will spend probably 2,000 hours divided among probably 50 lawyers on these issues. Since this is a legal question, there's apt not to be much, if any, testimony in the case. It's purely a legal issue. Facts really don't matter in this context, other than the fact that the client has to have standing. The person who is the lead plaintiff will need to have standing. Now, the plaintiff's arguments are going to be very simple. The 14th Amendment means what it says. So let's take a look at what it says. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Well, the first sentence is the most important sentence there. Let me explain why. First, a person has to be born in the United States, because we're talking about birthright citizenship. If they are born in the United States, they also have to be subject to the jurisdiction thereof. And for example, the child of the ambassador of Ghana is not subject to the jurisdiction thereof, because they are citizens of a foreign country and they have no intent to remain here. They are here as diplomats, and as a result, they don't get to claim United States citizenship for their children. Now, it's an interesting fact that just because you're born outside the United States doesn't make you a non-citizen. A rather famous gentleman by the name of John McCain was born actually in the Panama Canal Zone, but he would have been a naturalized citizen because he was born to American parents in an American protected zone, the Canal Zone. So there's a little history for you. But like I said, the first sentence is most important. If you are born on United States soil and you are subject to the jurisdiction thereof, and of course an illegal alien would be subject to the jurisdiction of the United States, that's what gives us the right to essentially detain them. That means that child is a citizen. So That is the assertion of the people who will challenge this. The rules regarding how constitutional provisions and statutory provisions are interpreted are set in stone, more or less. When a court sets about interpreting constitutional provisions, these rules apply. First, there's the ordinary meaning canon, sometimes called the plain meaning rule. It says words are to be understood in their ordinary, everyday meanings unless the context indicates they bear a technical sense. Essentially, courts interpret constitutional provisions the same way they do statutes. They use the plain and ordinary meaning of the terms found in the provision. More importantly, they use the fixed meaning canon as well. That says that the words must be given the meaning they had when the text was adopted. And of course, this is the part of the canons of construction that will be articulated in support of this executive order, because it wasn't meant to provide for what people call anchor babies. This is an important rule, and to understand it, we only have to turn to a case from 1926, United States versus McBoyle. In that case, the government alleged that McBoyle hired a pilot to steal an airplane and fly it from Illinois to Oklahoma. McBoyle denied the charge, but the jury convicted him anyway of interstate transportation of a stolen motor vehicle in violation of federal law. Now, today we think of motor vehicle as a car or a truck or a motorcycle, a golf cart, something like that. The National Motor Vehicle Theft Act of 1919 defined motor vehicle to include an automobile, automobile truck, automobile wagon, motorcycle, or any other self-propelled vehicle not designed for running on rails. So they intentionally exempted trains, and the other examples are all wheeled vehicles. The use of a statute designed for cars was just fine with the 10th Circuit. They affirmed McBoyle's conviction. They held that vehicle means any receptacle or means of transport in which something is carried or conveyed or traveled, because that was the dictionary definition at the time. The court realized there was some ambiguity in the statute, but it didn't think it would be inaccurate to say that a ship or vessel is a vehicle of commerce. And of course, they call them airships for a reason. The Supreme Court granted certiorari, and they reversed the Court of Appeals in McBoyle versus United States. If you want to go look it up, it's 283 U.S. 25. It's a 1931 case, and it is available on the internet. A unanimous court held that the statute making it a federal crime to move a stolen motor vehicle in interstate commerce didn't apply to a stolen airplane. They said, no doubt etymologically it is possible to use the word vehicle to signify a conveyance working on land, water, or air. Indeed, that's the plain meaning of the word vehicle, as the 10th Circuit found both by derivation and definition. But the Supreme Court said it was impossible to read the words of the statute, particularly the definition found in the statute, that so carefully enumerate the different forms of motor vehicles that have no reference to any kind of aircraft, as including airplanes, under a term that usage more and more precisely confines to a different class, meaning, of course, cars, trucks, vans, motorcycles, that sort of thing. The Supreme Court said that contemporary usage had effectively narrowed the plain meaning of motor vehicle in the dictionary sense to land-based vehicles. But in everyday speech, vehicle calls up the picture of a thing moving on land. That's what they said. Citing the principle of fair play, it said it's reasonable that a fair warning should be given to the world in language that the common world will understand, of what the law intends to do if a certain line is crossed or passed. To make the warning fair, so far as possible, that line needs to be clear. So basically, when the Constitution was adopted, specifically the 14th Amendment, what did those words mean? Based on the rule of plain language, the term all persons born or naturalized in the United States seems pretty clear to be talking about anyone born physically in the United States. Based on the canon that requires us to look at the way the word was understood at the time the statute, or in this case the constitutional provision, was drafted, there is an argument that says, hey, it wasn't meant to cover this particular situation. So both of those canons provide for non-frivolous arguments to either strike down or uphold this executive order. The problem is that in most cases, when you're dealing with a more liberal court is going to be much more likely to certainly entertain arguments that go beyond the plain language, this ordinary meaning language, where you talk about what the words meant at the time. But Clarence Thomas, in his Bruin decision, did exactly that. He went to what did the 14th Amendment mean at the time of the founding. And so it's possible that he might be open to that argument, although the Supreme Court as a group generally tends to apply the plain meaning rule first, because there's no except in there. The rules of construction say that if the words of the provision are clear and unambiguous, and those words are certainly clear and unambiguous, a person born in the United States, then the provision must be understood to mean what it says and be enforced in that manner. Put another way, you don't get to resort to legislative history or explore the intent of Congress during the drafting of the provision when there is no ambiguity. The counterargument, like I said, is in 1868 when the 14th Amendment was ratified, no one thought the provision would be used as a vehicle through which foreign nationals could come for a visit, deliver a baby, and then tack onto that child's citizenship to claim citizenship for themselves. And that argument is no doubt true and correct, but it's also largely irrelevant because it's trumped, pardon the pun, by the plain language rule. The same plain language that I seem to be having trouble with this morning. In order to end birthright citizenship, the only thing Congress can do is amend the Constitution again to reflect that change. The Constitution can be amended in one of two ways. First, an amendment can be proposed either by Congress with a 2/3 majority vote in both the House and Senate, or it can be called by a constitutional convention of at least 2/3 of the state legislatures. So far, none of the 27 amendments to the Constitution have been proposed by constitutional convention. The Congress proposes an amendment in the form of a joint resolution, and since the President doesn't have a constitutional role in that amendment process, the joint resolution doesn't go to the White House for signature or approval. The original document is forwarded directly to the National Archives Records Administration for processing and publication in the Federal Register, and then it goes out to the 50 states to be ratified. But if Congress is the one who has to propose this and get it done, which is the way it's traditionally been done, you'd need 290 representatives and 66 senators to propose that constitutional amendment. And then you'd need the legislatures of the 50 states, or at least 38 of them, you'd need them to ratify the amendment. Given the very narrow split between the Democrats and Republicans in the House of Representatives, and the fact that there's only 63 Republicans in the Senate, it isn't likely that the 14th Amendment is going to get modified anytime soon. So that would make the job of the courts rather easy in this case. The injunction, when granted, is more likely than not to stand. And if not granted, that decision would be overruled and the execution of that order would be ruled unconstitutional. Maybe you don't like that result. I understand that. You may very well believe that America is for Americans and we shouldn't allow people to come here and have babies and be citizens. Unfortunately, the U.S. Congress in 1868 disagreed with you. But here's why this EO and the decision blocking it when it comes is really nothing for anybody to worry about on either side. The way you prevent a child of a foreign national becoming a citizen is by preventing the foreign national from coming into the country in the first place. You seal the border, you prevent illegal crossings. This is not hard. You also strictly limit asylum claims and you deport illegal aliens immediately, and that's pretty much what Trump has proposed.
All illegal entry will immediately be halted, and we will begin the process of returning millions and millions of criminal aliens back to the places from which they came.
I'm pretty sure that's the plan at this point anyway. So again, the way you keep the cows out of the cornfield is you lock the gate. That's also how you keep the calves out. That way you don't have to torture the language or the history of the 14th Amendment to rewrite it. So that's what I have for you today. Thanks for watching my video. If you have a request for me to cover a topic, please send me an email to the address above and in the subject line put video request. If you have comments, drop them in the comments down below. If you found the content worthy, please consider subscribing. Since I started doing this work, I have always asked listeners to consider doing just one kind thing every day to make somebody else smile or make their life better in some way. Please consider doing that. It makes the world a better place. Now, YouTube has some suggestions for other videos of mine you may find interesting.